Yes.
It's now exactly 2 o'clock. We will resume our session. You can switch on your mic, Mr. Samuel. I'm just going to check if members in the virtual, if they can hear us. Namadzinga, can you hear us?
Yes, Chairperson, I can hear you loud and clear. Thank you.
Thank you. Thank you. Thank you, colleagues. Let's proceed. I recognize Advocate Bauer.
Mr. Samuels, we dealt with the Vrede issue, and I sort of didn't take you through your affidavit in the order of what it was deposed in order to get that out of the way. But so let's go back to the start of your affidavit. And deal with that. You've already dealt with the aspects of how you came to up to 70. You explain the fact that you haven't received all your emails, and you set out the background to the evidence that you have presented in the first few paragraphs of the affidavit. We have also dealt with your background as a provincial representative, and in paragraph 15, we essentially set out what the tasks are of that office, and I don't believe that to be of any contention. And then you say that in your capacity as provincial representative, if I can take you to 15.7. You talk about attending quarterly management meetings. I'm at page 2074.
Are you able to fly it back? Go ahead, Advocate Bauer.
Okay. We're at 15.7. You refer to 3 kind of meetings that took place. Can you just briefly describe that?
Yes, Chair. One was the think tank meeting, which would be chaired by the public protector, where all the senior managers and sometimes the relevant investigators and senior investigators would sit at this committee and discuss reports that were ready to be issued or that were ready to be finalized. This think tank essentially did quality assurance of those reports. And then there were management meetings chaired by the Chief Executive Officer, which included submission of reports from each of our offices or units, and these included scrutinizing financial reports, management reports, and reporting by the management team on the state of affairs in their respective provinces. And then there was a separate forum, which was the Provincial Forum, where only the provincial managers, the 9 provincial managers, would sit and engage with the executive managers to whom they report about issues peculiar to their respective offices. So those are the 3 main meetings of the 3 forums that we would attend once a quarter.
And you would be part of the management meetings where budgets would be discussed and allocated, correct?
That is correct.
And how would you get a provincial budget?
When we have ascertained as an office generally what our budget for a particular financial year is, the CEO would then instruct that all the provincial and investigation unit managers, or including HR and so on, should prepare their own budgets for their own units, and would submit those for approval. And it is on the basis of those reports that funds would be allocated to us.
And so when you need funding, you have to requisition that from head office, correct?
That is correct. The budgets were managed and expended from the central unit at head office.
And does the PP have any involvement in this?
No.
And if it's supply chain management, which affects you, does the PP have any involvement in this?
No.
So she doesn't get involved in the financial toing and froing between you and head office?
Yes, no, she doesn't.
Now, the think tank was at some point abolished, correct?
That is correct.
Do you more or less have an idea as to when that was?
I don't quite remember, but from the records or from the emails that I could trace, it would appear that the last think tank was around November or thereabouts, 2018.
In paragraph 18 of your affidavit, just 5 or 6 lines down from the bottom, and I'm not going to, Mr. Samuel, I'm not going to read or take you through every aspect of your affidavit, but just pick on stuff that I think the committee would require some clarification on. You refer to the Vrede investigation as being politically sensitive. What do you mean by that?
Prior to the arrival of the current public protector, we had a system under Advocate Madonsela of classifying investigations and complaints in terms of the nature and the relief sought. And so politically sensitive investigations would be investigations that were either lodged by a political party or implicated a political figure, and generally, complex investigations around tender irregularities and so on, which implicated politicians.
Right. So if you then go to paragraph 19, you set out your investigation processes. It is so, Mr. Samuels, does the PP sign off on all investigations?
No, only on the formal reports on all investigations which where a formal report has to be issued. There were some that were confined to or delegated to us to sign off.
So the run-of-the-mill complaints, and I don't mean to denigrate the complaints in any way, but there are a number of complaints that you would deal with at provincial level that would just get dealt with, that would never come to head office.
Yes, correct.
And you say in paragraph 20 that the overwhelming majority of the cases get finalized without formal investigative reports.
That's correct.
What's the difference between a closing report and a formal report?
A formal report is one where we would, have investigated complex issues and issue a formal report to be signed by the public protector. And a closing report would be on ordinary investigations, or even if the complaint emanated from, say, a politician or involves tender irregularities, but we found that they were unfounded, and we could not even commence the investigation. We would then do a closing report on those. Those were generally delegated to the heads of the units and the provincial offices to sign off.
Right. Now, in paragraph 22 onwards, you talk about the circumstances that you submitted the initial affidavit, and you essentially in that affidavit, and I will just read it to you, it's on 2756. You say, that you effectively sought the intervention of Parliament in taking any action necessary to safeguard the existence of the institution and investigate the operations of the office and the conduct of Advocate Mkhubane. See that on 2757 at paragraph 6.1.
Yes, that's correct.
And you then say, I'm speaking with confidence when I say that the majority of staff that I interact with, especially in management, have lost faith and trust in Advocate Mkhubane. How do you obtain such knowledge?
I interact generally with staff from different offices, especially in management and also below management, and these views were aired in my interaction with staff members that were free to speak to me, that we would constantly discuss with over the years.
And if I go back to your affidavit at paragraph 22, you say you're concerned about the decline within the office and unhealthy working conditions that was filtering down to the provincial office. And how did you see, we'll come to the details of working conditions in a while, but how did you see this filtering down to provincial offices?
To be specific to my office, I would have staff that was reporting to me, questioning how we would have come to some decisions as the management, and they would not be satisfied with, when, for instance, I tell them that this is not a decision that was taken in management, it's been filtered down to us as a decision taken, for instance, at EXCO. And as a result, we could not question some of these decisions. But there was generally, some, fear and apprehension from a lot of staff members and others outside of the office about the working conditions that were prevailing there.
Okay, so Mr. Samuel, you then talk about reckless litigation Can you tell us, maybe in brief, what do you mean by that?
What I mean by that is litigation that is not informed, or that is basically ill-informed, that is not necessary, that only takes place because we have the money, as an institution to engage in that litigation. It doesn't bring any value to the institution. And the decisions taken to engage in that litigation where known are really unnecessary. That is what I generally mean by it.
And then in paragraph 26 onwards, you give some examples. In fact, you refer to the litigation in the CX report matter in
That
paragraph
is correct.
26. And I'm just going to pick one of them. You in 26.2, you refer to the litigation in respect of the Vrede dairy matter. Correct?
That is correct. Yes.
Right. And so we can just go there. Right. Okay, so Mr. Samuel, you refer to the litigation in the Vrede Dairy project. That's the matter we discussed earlier on. And then you say in 26.2 that whilst the PP initially elected to abide the matter, they then opposed it in full, and that 3 counsel were briefed to represent the office in one application and 2 in the other, which you regarded as inexplicable given the limited resources of the office. Correct?
That is correct.
And you then refer to saying the High Court declared the report invalid and set it aside, and then issued a declaration that the PP had failed to discharge their duties under section 182.
That's correct.
And so if we go on, you make reference to paragraph 43 of the judgment. It's the judgment of Her Ladyship Talmay. So then I might have the wrong judgment. It's the wrong judgment. Give us a sec. 40, honey. 40. Sorry, not 34, 40. We go to paragraph 43 of the judgment. Where the court said, seen within the context of the factual background, the scope of the investigation as identified by the PP seems to be too narrow and seems to ignore the issues raised in the report from Treasury, the media reports, as well as the complaints lodged. And the court concludes there does not seem any logical and legitimate explanation for the narrowing of the scope of the investigation. Is that what you're referring to?
That is correct.
And then if you go to paragraphs 47 to 49, The court says her decision to limit the scope of investigation so dramatically was irrational as it sidestepped all the critical aspects regarding the complaints and led to a failure on her part to execute the constitutional duty. It then says in a report, the PP indicated that on assuming office during 2016, she took the following steps regarding the investigation of the project. She sourced additional 4 additional documents, the list of employees, the milking records, the financial records, and the company records. Those were obtained in the Free State, correct, Mr. Samuels?
That's correct.
Right. She held 3 interviews, namely with the Free State Department of Agriculture, the manager of Stadbrook, SA Holstein Breeders Association, and with the CFO. That is the SA Holstein Breeders Association from whom you obtained the pricing for the cows, correct?
That is correct.
She conducted 1 inspection in loco that you've told us about. She consulted 1 website, the CPI website, to confirm the details. That would also have been done, right?
That's correct.
Right. And then in paragraph 67 of the judgment, or let me go to 60 first. The court concluded significantly, whereas the provisional report had sought to give effect to Treasury's investigations and recommendations, the PP did not accept these findings. She instead found the compliance with the requirements of concluding a PPP was not required for the Steiner agreement. On what basis she could justifiably come to such a conclusion is unclear. It points either to ineptitude or gross negligence in the execution of her duties. And then at paragraph 75, the PB also determined whether the prices for goods and services procured were inflated. On this issue, the provisional report stated that independent evidence indicated that prices of processing equipment and the cows purchased were considerably higher than market value, which confirmed the proper procurement processes were not followed. It indicated that lack of proper monitoring and control measures were the reasons for discrepancies noted in the financial statements, which in turn pointed to gross negligence and maladministration, which led to fruitless expenditure. And these were one of the findings that were excluded from the final report. Correct, Mr. Simon?
That is correct.
Right. And so I'm not going to take you through all of it, but if one reads the remaining subparagraphs, you refer to various paragraphs in the judgment in which conclusions are reached. Correct?
That's correct.
And if you go to the, and there was then a second judgment handed down where the court concluded that the public protector should be personally liable for 7.5% of the applicant's cost on a punitive scale. You see that at 26.3 of your affidavit.
That is correct. Chair.
And this judgment, as you point out in 26.4, was leave to appeal from the High Court, then to the Supreme Court, and then to the Constitutional Court, and in each case the application was dismissed.
Correct, Chair.
In 26.5, you deal with the litigation regarding the Financial Sector Conducting Authority report. Correct?
That's correct, Chair.
And then in 26.7, you deal with the litigation regarding report number 37 of 2019-2020 and the findings made by the court in that case.
Correct, Chair.
Right. And in 26.8, you point out that again, that was taken on appeal and was dismissed by the Constitutional Court. Right.
That is correct.
And you come to 28 and you say, this was a sample of cases which concerned you at the time.
That is correct.
And did this give rise to adverse media coverage?
It did, yes.
And did it reflect poorly on the reputation of the OPP?
Yes, it did.
And did it give rise to criticism against the public protector and the OPP?
Yes.
And, and why do you think that that occurred?
It was because the continued loss of pursuit of this line of litigation, and with the resultant losses, put the office in a bad light. It reflected generally that we did not know what we were doing as an office, and there was a marked decline in the confidence, of the office from the time before Advocate Mkhwebane came in and during her term when this litigation was taking place.
Right. And then if you go to the next section, which deals with soaring legal costs. In your affidavit, you mentioned earlier that you obtained this, you became aware of these legal costs because of quarterly management meetings, correct?
That is correct. Sure.
Right. And you make reference to the annual financial statement in these subparagraphs.
Correct, Chair.
Right. So let me just take you quickly. On the screen, if we go to Annex SS1, which is 2150.
Yes, Chair, I'm there.
Right. Under the heading of administrative expenses, scroll down.
Yes.
One sees legal fees in the 2016 year to be in the amount of 5626607. See that, Mr. Simons?
Yes, I do.
And in the 2017 year, you see it at 6446038.
That is correct.
If you go up further on the schedule, you will see a heading that says consulting and professional fees. It's line item 6.
Is it in the same page?
Yeah,
It's there.
It's under number 18, it's number 6. That's the 6th item. It says consulting and professional fees. Sorry, Mr. Samuels, I know it's a bit small on the. Just look under C, it's the last C item on the list. Just above legal fees.
Yes.
You will see that there was an increase from approximately 1.5 million in 2016 to over 5.2 million in 2017.
Yes, I see that.
Then if you go to the following financial year, which is at 2159, you no longer see legal fees, Mr. Samuel, but you see under the heading consulting and professional fees. They've now joined legal fees with consulting and professional fees. We know that because there is a footnote in the annual financial statements that tell us that, correct?
That is correct.
And so the 13 million of 2017 would be the two totals that we had read separately. The previous year, more or less, there's a bit of an adjustment. And that's increased to 24 million.
That's correct.
Okay. And if you look at page 2167 of the financials,
You mean the face?
Oh, no, we must go
See?
down to the words,
Okay.
right? If we go to the fourth paragraph in the second column,
Yes.
it says, as one of its legal strategy, the PPS has not been defending all matters taken on review in a plight to reduce costs. The expenditure on legal fees is reduced by 6 million from the 2017-18 year of 20 million to 2019 year of 14 million.
Yes.
See that?
Yes, I
So-
see that. Sure.
If we then look at the financials at page 2, I think it's 2171. The 24 million on the fourth column becomes approximately 18 million, 17,940,000. I must go down. It's the fourth item under 21.
Yes. Yes, I see that.
Then, Mr. Samuels, if I take you to 2187.
Yes, I'm there.
It's the fourth item under number 20.
Yes.
So the 17,189,000 became 47,200,000 at the end of the 2020 financial year.
That is correct.
And so if I go back to your affidavit, you in paragraph 35, your complaint was actually based on 10 million rand being budgeted for legal fees in 2019, 2020, and you thought that was a record high amount. Isn't that so?
That is so.
So you then say you actually underestimated the amount that was actually spent.
Yes, I did. This was based on the documents that we were receiving in the management meeting at the time.
And those would be quarterly documents, so they wouldn't always be entirely accurate. You would agree with that?
Yes, I agree.
Right. And why did this concern you as much from your office as a provincial representative? How did it affect you and your office?
It meant that other programs in the office would suffer because money that was budgeted for other programs was now diverted to legal fees. And the principle up until then that we followed was that we are not an institution that is involved in litigation as our primary function. But, this trend showed that we were slowly getting more litigious and to the detriment of other programs. And this affected also the province that I was responsible for.
Okay, so let me take you to paragraph 48 of your affidavit where you talk about some of these programs.
Yes, I'm there.
It's on page 2093. And you refer to the holding of outreach clinics. Now, talk to us a bit more about that, Mr. Samuels. What does that entail?
These clinics were a means of us as an office meeting the constitutional mandate of being accessible to all communities. It meant that we would have to go to the communities, especially those that were far flung from the office or the offices where they could just walk in and lodge complaints or get information about the services of the public protector. And so it allowed for our outreach officers, and sometimes accompanied by investigators, to have a direct interface with members of the public. And in that process, they would then explain what our office was about, obtain, assist complainants to complete the forms where they wanted to lodge complaints, and come back to the office with those complaints.
Right.
That's what the clinics generally entail.
And most of the PP's offices are actually established in the big cities, correct?
That is correct.
So this was a one.
With a few regional offices, what we call regional offices, in places other than the cities.
You have, in the Free State, there was one regional office
That is correct.
under your control, correct?
Correct, yes, in Provincial.
Now, you then quote as to what the objectives of the organization was in 2016, 2017, and maybe if you can just read that to the committee. It was as detailed in the annual report.
When the public protector first started in the OPP during the 2016-17 financial year, she had a vision, which she called Vision 2023. But within that vision, she had, as a matter of emphasis, a vision to make the office more accessible, and to that extent suggested a few mechanisms within which we could reach that. And so in the financial year, in the annual report, she recorded that in the early stages of the launch of her blueprint document, Vision 2023, she envisaged taking the services of the public protector to the grassroots. And that Vision 2023 seeks to ensure that we dedicate more of our time and resources to our services being filtered to communities living in the margins of society. She states that it is her belief that they too deserve a taste of the fruits of freedom and democracy, and that we intend to achieve this by broadening access to our services, especially to rural and impoverished communities.
And did you agree with that approach, Mr. Sam?
Yes, I did.
And in the same report, the PP noted in your next paragraph that as many as 803 community outreach clinics were held countrywide, resulting in contributed to it, and that this contributed to the 9,563 complaints received during that period, correct?
That is correct.
And then you detailed two further aspects of the report. If you can maybe just take us through that.
The further aspects were that in the annual report, she stated that the institution's goal is to reach as many people as possible through its outreach activities. We reached many communities through our 803 clinics that were conducted during the period under review. Furthermore, the impact of the outreach activities such as media, house visits, numerous newspaper articles written about the office and interviews resulted in South Africans being made aware of the existence of the office, the work it does, and the type of assistance they can obtain. While millions of people were reached through outreach activities, The objective going forward is to focus more on bringing these services to people living in villages and townships.
And so what does the next annual report record?
It states that for my office to make a meaningful contribution towards its shared responsibility of strengthening constitutional democracy, our services must be accessible to all. The success I referred to above could therefore not have been possible without our efforts to enhance access to our services. In the intervening period, 815 outreach clinics were held to take our services to far-flung communities. With only 19 offices countrywide, these clinics make up for our limitations where our footprint is concerned.
Right. And then in paragraph 54, you talk about the next financial year, 2018-2019. And if you turn the page, what does it say?
Making the Office of the Public Protector accessible really changed significantly, and for the worse. In that financial year, 2018-19, she stated that other targets included conducting 208 community outreach clinics and 36 radio slots also by the financial year end. And that clinics are mass meetings where presentations on the public protector's mandate are made in vernacular to remote communities. Complaints are also lodged during such outings. Slots, on the other hand, involve call-in programs on SABC and community radio, where the message about this institution is spread. These two targets relate to the enhancement of public access to the services of this office.
So what happened, Mr. Simons? It got reduced.
Yes, they got reduced. From the figures that I mentioned earlier, they went down to 208 for that financial year. And this was despite acknowledging the usefulness of those clinics.
And how does this affect a province where you're operating?
It meant that it affected, firstly, our targets, which generally would have been perhaps reduced in order to meet those lowered targets, but it meant that we could not reach the communities that needed our services. Okay.
But you then go on in paragraph 57. It did exceed the target that was set by 69. They held 277 community outreach clinics when the plan was only 208.
It is easy to exceed the targets if you have reduced them. Generally, the practice had always been that we increase them each year and not decrease them. With the rider that we would have to go to other areas that we had not concentrated on in the previous year. So reducing them made it easy to effectively manage, to justify spending our budget and meeting our targets when in fact they were, these targets were reduced.
Oh, in paragraph 59, you say that there was a preference to radio engagements, but don't you reach more people with radio engagements?
Yes, a lot of people listen to the radio, especially those that are in rural areas. They listen mainly to the radios, but it is one-sided. We can only tell them what our office does, but they cannot then thereafter contact our office to lodge complaints because it's over the radio. And invariably, these radio slots would not be call-in programs, to be one way where our outreach officers speak to the radio stations from the comfort of either their homes or the office and they do not have any contact with the complainants.
And when you go out on these outreach clinics, are you expected to assist complainants in filing complaints?
Yes, that's why in most cases we send them with at least one investigator who can also give advice on the spot on alternative avenues through which complainants can resolve complaints where perhaps we don't have jurisdiction and so on. But largely, in order to receive complaints, we would have to assist them by completing the forms that we would have taken with us to those clinics.
And did the PP's office have a toll-free number?
Yes, we did. And I'm not sure that it's still there, but it is based at head office. If you call from anywhere in South Africa, it gets answered at head office. And the practice in the past was that where a complaint could be taken over the phone through that channel, it would then have to be sent to the nearest office where the complainant is based so that we can obtain further information and conduct the investigation. But all the other offices did not have, would not get those. I mean, complainants would have to phone directly to our local numbers and at expense to themselves.
Right. You then refer to the need for cost cutting in the paragraph 60.
Yes.
And you refer to the 2018-2019 report. Can you elaborate on that?
Yes. There it was justified in the following terms that the PPSA implemented various cost containment measures from 2017 in an effort to reduce actual spending on non-essential expenditure. On non-essential expenditure items like travel and subsistence, accommodation, catering, advertising, and outreach programs. This resulted in PPSA reducing actual expenditure significantly from 9.5 million in 2016-17 to approximately 3.5 million in 2018-19.
And so what was your issue, Mr. Samuel, with this?
The issue was that if we made this kind of saving, where was the benefit? Where would it be absorbed? And so it was actually absorbed in litigation costs. That is what I meant by saying that a lot of other programs suffered because what we're supposed to do, for instance, for outreach or even for investigations, traveling to wherever we had to travel to and conduct investigations, that money was then channeled elsewhere to litigation. And, outreach cannot be described as a non-essential expenditure. It is a constitutional imperative as far as the Office of the Public Protector is concerned, along with investigation and reporting.
No, I'm sorry, I skipped over that, but you do say earlier that under section 182(4) of the Constitution, the office must be accessible to all persons and communities. Is that what you're referring to?
Yes, that's what I'm saying.
And then you talk in paragraph 65, you deal with the impact on investigations and administration.
Yes.
Right. And
yes.
You already had talked about requisitioning funding from head office, correct?
That is correct.
And how did that impact on your operation in the provincial office?
The impact was that even though we had our own provincial budgets and funds were allocated in terms of that, when we tried to access the funds in order to operate, from our budget, which was centrally controlled at head office, those requisitions would be declined. And, you know, the only reason invariably would be that funds are depleted, even though we knew that we had not used up our budgets. Because what we do is to plan it for the whole year. And sometime during the middle of the year, you're told that your budget is depleted.
You then also mentioned that you were grounded. What did you mean by that?
Traveling was not allowed. You know, it literally stopped. And the vehicles that we had as pool vehicles in order to travel, either for outreach or investigations, they were grounded. They could not be driven anyway. All the traveling was cancelled, including for us as senior managers who had to use our own vehicles, but claim for the expenses, you know, for the traveling from the office.
And Inspector of Investigations, could you go out and investigate?
No, we effectively did our investigations from the office, you know, from the desktop, from our desks, either calling the departments or sending emails and so on. We could not go and do inspections or go and meet with complainants and so on.
And this was in the 2019 period, 2018-2019 period.
That is correct.
Did you ever raise this, Mr. Samuels, these concerns?
Yes, I did. I raised them in the management meetings, which had by then been reduced to being conducted virtually. From our offices, we would log in and be in a management meeting. Those continued, the management meetings.
And what was the response you got?
Invariably, that, you know, the response would be that we must take, you know, the issue outside of the meeting and, as you know, individually, you know, ask the CEO what the reason was. And when you do take it out of the meeting and you contact the CEO, he tell you that there's no budget. The money has been depleted. And
who took the decision? Who would he say?
He would just say the decision was taken at EXCO, and EXCO was comprised of the public protector, the deputy public protector, and the CEO.
And you say there was also, if you look at paragraph 73, you deal with the think tank.
Yes.
Right. And you've already explained what the think tank was.
That's correct.
And that was initially you said that the think tank had operated.
That's correct.
Right. And then it was not operating any longer.
That is correct.
And so what was your, surely Mr. Samuel, any person who comes into office can change how matters operate within the office.
Yes, that is correct.
Right. And that doesn't necessarily, there's nothing wrong with that. You agree?
Yes, there's nothing wrong with that. You know, we don't have to continue operating the same way simply because things have been done that way. I mean, there could be various reasons that influence the necessity for a change, and so it is up to within the, you know, the ambit of the leader of the institution, in this case the public protector, to change how we do things.
And I understood it manner in which the think tank operated was that everybody from across the country would converge into Pretoria for a few days every quarter to consider reports. And by abolishing that structure, you saved time and you saved cost, didn't you?
Yes, that was the case. But it also affected the quality of the reports that would have been subjected to peer review in those think tanks. And this is borne by the fact that the think tank came from the time when Advocate Mshwana was the public protector. He introduced it. Advocate Matonsela continued with it, and Advocate Nkwebane also continued with it for a period and then stopped it. And our view was that it really assists where we all come together and quality assure the reports to assess their readiness to be released. And we had a lot of success based on that peer review mechanism.
But in making away with think tank, it wasn't that there was nothing that replaced it.
There was nothing wrong with doing away with perhaps traveling all the way to head office for all managers coming from different provinces. But consideration could at least have been given to continuing with the think tank virtually, at least to see if it's going to work or not.
Did you suggest it at any stage?
No, I don't recall suggesting it.
And so there was a quality assurance mechanism in place to consider reports, wasn't there? When think tank didn't exist anymore.
Yes, there was.
Right. And what was the difficulty with that which was put into place?
There were different things that were tried. I think at some stage there was what was called the task team. And then at some stage, and these comprised of lesser people and mainly senior investigators. Maybe 2 or 3 would be assigned to quality assure the reports. And then at some stage, she then, with the public protector, then directed that reports should be sent to her via the senior manager for legal services. It was just one person who had to then quality assure all the reports coming from all the provinces, and the work was way too much for him. Essentially, there was nothing wrong with that, provided it yielded the results that we wanted, meaning the quality of the reports would at least either be improved or remain constant as we are used to. But my assessment is that is where everything went haywire. The challenges to our reports increased successfully so.
But there was a certification process put in place, wasn't there?
Yes, there was.
Where as managers and as senior managers, you had to take responsibility for the reports coming out of your provinces.
Yes, there was. That certificate of compliance that she introduced, starting with the investigator who is assigned to do the investigation. When they hand it over to their line managers, they would have to sign that certificate of compliance. It was a good innovation, and all the way up to the time it gets to her, that had to be completed.
So and then there was an issue of training. You had some cause of concern for ongoing training within the organization?
Yes, training had always been provided since I joined the office because in 2000, because at any given point in time, investigators would either resign and go to other institutions and new investigators appointed. So there was always a need for continuous training. And, some of the training we got from judges, would request judges to come and speak to us about drafting reports and making sure, that the reports that we produce must be foolproof, and what needs to go into those kind of reports. That was certainly the case with Advocate Madonsela, and would also get training from other ombudsman's offices outside of South Africa, and we also had trainers within the organization that had all the experience, the institutional memory that we had to train others as they come in. But it was done away with. My recollection is that when the public protector came in for the first time, she came in when Advocate Madonsela was supposed to come and present the performance report of the office in the week that she was supposed to finish. And so the committee then decided to postpone that sitting to the following week, by which time she would not be the public protector. But the arrangement had been that she wanted to be accompanied by all the provincial managers in that sitting. Advocate Mkhwebane, did not change that. We all came here, met with the portfolio committee, but one thing that was said in the portfolio committee was that, I remember it was chaired by Dr. Mathole Motshekga. They made a request to Advocate Mkhwebane to say the office should not use or accept consultants or trainers from outside, because there's no such thing as a free lunch. And she made an undertaking there that she would not do that.
And so there was less external funding for purposes of training.
Sorry, could you repeat?
So that funding that previously been available was no longer.
Yes, it was no longer there, because we would either get funding from foreign governments. Like I remember more particularly the German government, or some NGOs in Germany that would fund us, specifically our training at no cost to the office.
And you say that even other kinds of training that didn't have cost implications.
Yes, no, all kinds of training effectively stopped. And I it had the effect of affecting the quality of our reports.
Okay, in paragraph 91 onwards, you talk about a unhealthy workplace. Right?
Yes.
You were a member of the trade union, the Public Service Association, correct?
That is correct. I'm still a member of that union.
And yes. And how did you obtain information about what was going on in the organization?
Information would come from the PSA when they briefed all members, either through circulars or meetings, about the kind of complaints they are getting, from members regarding the way the office was operating and or against the public protector. And so they would brief us all about their engagements with the public protector or with the office in trying to resolve those complaints. So that was one way that we got to know about what's happening in other offices as well.
You then in paragraph 92, you talk about the impression you had about information. Talk about that.
Yes, the view that we all had, or most of us had, particularly as senior managers, was that when the PP came in 2016, she had some kind of knowledge about some of the activities that we had been involved in individually. In 2017, I think it was, when she made the opening remarks in one strategic planning session, which we generally hold around October, November. She went to town attacking some of the managers, or most of them, with specific information about what they allegedly had done or that she knows. I was one of those. When she mentioned in that open forum that I had allegedly assaulted a complainant, or she didn't put it as an allegation, she just put it as a fact that I had assaulted a complainant, and said, imagine what the media would do if they got wind of that. And then she should go to the next person and attack them directly. But that is what she then she did in that forum.
And wouldn't it have been expected that she knew this information because she was the head of the organization?
When we discussed that during the break, we thought that the fact that she came from the SSA might have given her that advantage to know that information, because we did not. We had a copy of the handover report from Advocate Madonsela. This is not any information that would have been relayed in that kind of a handover in that report. So we had no idea where she got that from.
But it was merely a suspicion.
Yes, it was a suspicion. I mean, we don't have the facts. I'm just mentioning it because that's what we thought at the time.
You then say she sought to undermine the work of the office. Can you explain that? And that lots of people left the office, or that rather it be not overstated that there was a high departure rate of senior staffers. At 95.
Yes. Before she came in as the public protector, the office, I remember even in the interview that she went to, the politicians there kept saying to her, you're going to an office that is high up there, that has over the years built up a good prestige and is well known, and it has got success in its operations, and they impressed on her not to undermine that kind of prestige. But her actions immediately she came in, starting from that time, was to either force people out, especially senior managers, or make the situation so untenable for them that they ended up resigning.
In which way, Mr. Samuel?
she introduced, for instance, when work was concerned. Firstly, there were other committees that were in place at the time. I remember the editorial committee, which would then be the last committee that edits our draft reports before they get signed by the PP, and other committees that generally advise the public protector on the aspects of the report, to give her that satisfaction that the report is ready to be released and so on. All the people that were in those committees were forced out. They either resigned or some information would be used against them to force them out. As far as work is concerned, she took charge of all the investigations, all the complaints that we had as an office, from the simplest of complaints to the most complex. She introduced a system where we had to populate the spreadsheet. It was quite a huge, spreadsheet, and insisted that she wants reports on those cases every week. With the result that, it shifted our focus from actually doing investigations to only, meeting our deadlines, because some of the deadlines would be very tight. In some cases, she would perhaps have a meeting with a member of the executive, and would then be required to, in preparation for that meeting, at very short notice, to provide her with information, so that she can then meet with the members of the executive. And in most cases, this was information that would be requested of us nocturnally, and you'll only see when you get to the office at 8 and you log in that you have a deadline at 8. And that information, that request would probably have come the night before or in the early hours of the morning. And you'd start the day already knowing that you are late with your deadline. And that and failure to comply would be followed with some kind of consequence management, or you'd be given something that she introduced, an Audi letter, a letter where you'd be asked to give reasons why you should not be charged. And so it generally affected the morale of the staff. And that is how I make the observation that she undermined the work of the office.
If we can just take it maybe one at a time, on the weekly meetings on investigations and reports, what is so wrong about it? Because I understand that there was a huge backlog at the office, and there was a need, there was a desire on the part of the PP to work this backlog away and not leave it there for her successor. And so it became a mechanism by which this backlog was going to be eradicated.
But there was nothing essentially wrong with it. What was wrong, what was objectionable was that, the fact that in order to provide this information, we in turn had to have our own meetings. And so we spent most time, in meetings, collating this information, populating the spreadsheet, accounting to our executive managers, who would then sit in the meeting with her and get directives from her on each of those cases, how they should be handled going forward. But the very following week, it's the same thing again. Before the end of the week, we should have populated those, so that on Monday, when she sits with the executive managers, those spreadsheets are there. And it was the threats attached to not complying or complying late with those that really affected our morale. And there was nothing wrong, essentially, with taking charge of those.
And how did this threat you're referring to manifest itself?
The CEO would, she would demand that the CEO take action against those that did not comply, or demand that the executive managers take action, consequence management, either charge people and so on. So that was an everyday thing, that you'd have to justify why you should not be charged and provide reasons, and so on.
Did you get such an audit letter, Mr. Samuel?
No, fortunately, I never got that.
And was that because you didn't meet deadlines, or what was the reason?
No, I missed quite a lot of deadlines, but the reason why I missed them was because if a deadline is unreasonable and I have to give a report within that time, it would mean that I must give substandard work in order to comply. That would be malicious compliance. I would generally be late, but make sure that my report is thorough and it covers everything. That is what my line manager appreciated at the time. And so I think he would generally shield me from action. He refused to take any action against me where he also felt that the deadline was unreasonable, or the failure to meet the deadline was justifiable.
So you didn't face the impact of that kind of approach?
Yes, personally, I did not, because I insisted on rather taking my time doing what was required of me. Because once I append my signature to any report or any document, I take ownership of that, whatever is stated there.
And so when you talk about these deadlines, if you didn't submit by the deadline because you were ensuring a quality report, then it wouldn't actually impact on the quality of the report. Am I making sense, Mr. Samuel? If you took the time to finalize your report,
yes,
then would you accept that wouldn't have affected the quality of your report?
Yes, it did not.
So in paragraph 102, and I'm just trying to understand this.
102.
102. But there would be deadlines for investigation outcomes and reports. And if you could maybe just explain that in the context of your submission.
Advocate Kobane would demand would demand to say that certain deadlines be met, and that if you required any extension legitimately in order to comply fully and with a good product, she was very, she would not grant those. And people then, feared the consequences of the disciplinary action, and so would submit substandard work. And because they were not allowed sufficient time.
Were you given substandard work by people under you?
Yes, a lot.
And what would you then do with it?
I would take my time then to fix what I found objectionable with that work, so that as I send it on, it meets the required standard.
Even though you didn't meet the deadline?
Yes.
Okay. You then say that this resulted in an overworked and demoralized staff complement fearing in their jobs. And did you feel like that, Mr. Samuel?
Yes, I did.
And if there was no audit letter issued against you and you submitted your reports late, why did you still feel like that?
It's because no one can function normally if there's always a constant threat against you. And so at some point you have to make a choice whether, you should be charged for not complying at all or complying late and not for submitting substandard work. So that was my approach. It took its toll on me as well, but I preferred doing that than.
And do you think that as a consequence of adopting this approach, it resulted in shoddy work?
No, it did not from me.
And then you talk about persons who were unfairly, which you regarded as being unfairly targeted by the PP. I'm talking at 107 of the affidavit.
Yes.
Okay. And you refer to some of the people in the affidavit. And maybe if you can just, I'll give you an indication of who I anticipate to come and give evidence so that they can speak for themselves in doing that.
Yes, one of those, was Mr. Ndo, the executive manager to whom I reported. There were allegations of misconduct against him, which, and as a result of those, he was suspended, and an external law firm, Sphelo, was appointed to investigate the allegations against him. The law firm concluded the investigation and submitted a report which absolved Mr. Ndo of wrongdoing, and he returned to work. My recollection was that there was also a criminal case opened, which also didn't go anywhere because the senior public prosecutor declined to prosecute for lack of adequate evidence. More than a year thereafter, Mr. Ndo tendered his resignation, and in the week that he was, he was serving notice, and in the last week that he was serving notice, he was then charged for the misconduct that I've just referred to. And Mr. Ndo appointed me to represent him in the disciplinary hearing. But the disciplinary hearing never took place. It only sat once on that day, and we asked for a postponement because Mr. Ndo was actually off sick. And so the postponement was granted sine die by the chairperson, and that was the end of the matter.
You don't have knowledge as to what happened in that year?
No, I do not.
And then you refer to Ms. Mokhaladi?
Yes, Onaseho Mokhaladi is one of the executive managers at head office. She started off with me on the same day that we started in the 1st of December 2000 in the office as senior investigators. She was responsible for the investigation into the financial sector, what I can't recall the full name, following a complaint lodged by the EFF. The investigation led to a report that was challenged in a judicial review and set aside by the court. The PP alleged that Ms. Mokhaladi had set her up for failure because she had allegedly failed to consider information that was supplied to the office when conducting the investigation. Ms. Mokhaladi was then charged along with others, but eventually found guilty on some charges, but these did not warrant a dismissal. And even though, from the chairperson, even though the chairperson had found that they were not to be dismissed, The public protector then wrote to them to inform them that they must give reasons why she should not dismiss them. And they challenged that in the labor court and were then reinstated. But my understanding is that she's still proceeding, or at least the office is still proceeding.
There's pending litigation.
Yes, there's pending litigation. So if there's any further information, I'm told that Ms. Bukhaladi and another one might be called, and so they will talk to the details there.
And then in respect of Mr. Madiba, he's passed, right?
That's correct, yes.
And then you refer to other individuals who, all in all, I think in one or another will, Ms. Fasani Baloyi, and others that you refer to in your affidavit as people who you regarded as having been targeted and purged.
Yes, that's correct.
And that's in 123 and 124. Mr. Samuel, what's your what security clearance did you have?
None.
And you served on the think tank?
That's correct.
And did you apply for security clearance?
Yes.
And what transpired?
Nothing. We applied, I recall, about 2 times since Advocate Enquiry came in and insisted on that. But up until today, nothing happened with those applications. We completed the forms and supplied whatever information was required and sent it to the security manager, and he in turn sent it to the SSA, but no security assessments were done. Okay. At least up until I was dismissed. And yeah.
So the introduction of security clearance, or the necessity for security clearance introduced into the organization, was introduced by Advocate Mkhubane.
That is correct.
And prior thereto?
It was not a requirement. It was sufficient for us to just sign each time. I think it was annual, we must sign a confidentiality clauses, but the security clearance was never a requirement. It is now a requirement when they advertise positions relating to investigations and others, perhaps in finance and so on.
And in the 2 decades that you worked at the PP's office, did you need to handle top secret or classified information or anything of that kind?
No. The bulk of our work does not involve those. Where perhaps that might be a requirement, it would be in relation to information perhaps that one would have to acquire in the course of investigating the executive. And those have always been confined to the public protector to investigate. So I believe that the requirement would really be for her, not for us. And our documents were never classified.
And you regarded the imposition of a requirement of security clearance as a reason to have people removed or excluded?
Yes.
Can you explain that?
So excuse me, I didn't hear that.
Can you explain that?
Yes. Initially, we were very reluctant to accede to the instruction to do the security clearances, because it was the first time that they were being introduced, and we regarded that as a way of trying to remove us from our positions. This was particularly informed by the fact that the Deputy Public Protector at the time, Advocate Malunga, and the CFO at the time, Kennedy Kaposa, where there were issues around their security clearances, and so Kennedy Kaposa was effectively dismissed because of that. He did not have what the public protector considered to be an acceptable security clearance. But
That's
with
what you-
Advocate Malunga, he served his 7-year term as deputy public protector to the end.
You were not involved in Mr. Kaposa's labor dispute at all.
No, I was not.
I have no further questions. Chair.
You done? Thank you, Advocate Bauer. I think on that note, we'll take a 15-minute break for tea, and then we'll come back and resume and start cross-examination by Advocate Mpofu. Thank you, Advocate Bauer.
Recording stopped.
Thank you, Mr. Samuel. Let's take a 15-minute break.
I ran up 6.
Yes, 500 pages. Can we come in, colleagues? Can we come in, colleagues? Attention, let's come in, colleagues.
Recording in progress.
Thank you very much. Let me just check if those in the virtual are with us here. Honorable Dana, are you there? Padminen? Just checking if people are in this meeting.
You are here.
Chairperson,
you are not,
Honorable
you are not
Sphelo.
Padminen. Padminen, are you here?
Yes, I'm here. I can hear you, Chair.
Honorable Dana, are you here? Thank you. You never know who I call, so you rather stay online. Thank you, honorable members. You can switch on your mic, Mr. Samuel. We're back from tea. Again, I want to thank Advocate Bauer for the session of leading the evidence and the responses from Mr. Samuel. I'd just announced before we took tea break for 15 minutes that we'll come back and have Advocate Darling Bofu, as we normally do, to come in and start the cross-examination. I'm not sure if he's ready, Advocate Darling Bofu.
I'm ready.
No, thank you. But I think more on a serious note, in terms of our own assessment, we had to engage with the witness. I think he might need some support, as he would have indicated earlier on about some health issues. So for that reason, we're not going to start the cross-examination this afternoon. We'll pause with him and then start with that in the morning. And that's been our pattern and arrangement. Unfortunately, even for members, you can't, because your own role also starts with him to interact. So for that reason, today we will have a shorter day. We're not going to prolong the day for any other thing. And we're going to have to adjourn our meeting at this point and be back tomorrow to resume our work with Advocate Mpofu and thereafter to have the members interacting with Mr. Samuel. I see your hand, Mr. Mailam.
Thank you, Chairperson. Chairperson, I appreciate your guidance on this matter, but there is something that is outstanding, and that was the responses from the Public Protector to the questions that were raised over a week ago. And they were supposed to be in by Friday, 5 p.m. I don't believe any members of the committee have seen those responses as yet. And could we get some guidance as to what's happening with that?
You will get that guidance tomorrow morning. You can rest assured that we've been on top of that issue as a chairperson. So I don't want to start it now. If you give me that permission, thank you. Thanks for raising that. It's a matter that is handled by us quite diligently. With that, colleagues, our hearing adjourns for the day. Thank you.
Thank you, Chair, for the indulgence.